independent related with free courts initiative to support independent Poland, faculty of law and law. Ladies and gentlemen, we have this great to take the floor judge from the speech in order to end Q&A session with you. Judge Frąckowiak, please.
Thank you. Speech panel. The situation of very difficult, and it's the independence of judiciary we are talking about, but it's really we the members were quite aware that 1 year ago there were maybe
fictions like this basically take
this there thousands as a frequent
Warsaw Bar Association is extremely active in fighting against those threats to the rule of law from the very beginning. So when I remember for example, hearings before the Constitutional Court, it was always the Warsaw Bar Association that was presenting legal opinions on different changes to the statutes of the Constitutional Court, but also to the judiciary. And I must also underline that Warsaw Bar Association, and even in particular Human Rights Section, was also quite active in defending myself as the ombudsman against different threats and to the integrity and the independence of the office. So thank you very much for
our pleasure.
Okay, but now I would like to, if you could share with us, what is the perspective of the Bar Association, what are the current actions, what are maybe upcoming actions concerning the representation and challenges concerning the judicial independence, and why lawyers, barristers in particular, are so much involved into this issue.
Right. Good evening, ladies and gentlemen. First of all, a little disclaimer. I'm not a member of any official body of our self-government, like, for example, Polish Bar Council or Warsaw Bar Council. I'm just a simple attorney, and as such, I'm a member of Warsaw Bar Association. That said, I am here on request of our dean, the dean of Warsaw Bar Council, to provide you with some perspective on how the bar actually copes with the most recent events regarding the independence of judiciary in Poland. But I would like to start with a few words from myself about how, only in my opinion, the dangers resulting from the current state of affairs may affect an attorney and our actually professional practice. So, as one of my favorite singers would say, the judiciary is really under pressure right now in Poland, and so are we, the attorneys. Our everyday lives involve at least some contact with courts, and the case law is like influences all of our actions as professional advocates. It is common agreement that the real reform and reasonable, well-thought changes in judiciary were and are crucial to justice system in Poland as a whole. However, vast majority of attorneys will also probably agree that the real goal of the so-called reform that Polish government has been introducing for the last 2 years is not to make judiciary in Poland better or more just, but to subdue it to the executive power and to replace the independent judges with the ones that are loyal to the government. So separation of the powers and the rule of law, including independence of judiciary, for me, are topics not only for some theoretical discussion. All of this has some serious practical consequences for every citizen in Poland and for every practicing lawyer. The independence of judiciary is essential to ensure the right to fair trial. The latest changes in judiciary raise some serious concerns for us in our community over the cases that are pending right now and will be pending in the future. In my opinion, the issues include, among others, the pressure to be put by the government and politicians on the judges, and especially in politically sensitive cases. Second one is disciplining judges and intimidation of the judges, like Judge Frąckowiak said. And this may cause fear to judge independently against the government and politicians' will, or actually I think that it also may lead to obeying in advance the imaginary wishes of the government, which is very, very dangerous. The third thing is passing the sentence by a judge who is appointed by the body that is in fact elected against the constitution, and as a result there might be doubts if the sentence passed by him or her is even valid. And last but not least, such an issue might be passing the sentence in a court of appeal or in Supreme Court in that matter by a judge who actually does not fulfill the reasonable standards for even being a judge. So for me as an attorney, it is crucial to know that the judge before whom I stand is independent. Because only then I know that I can reason with them. I can win or I can lose, but I always stand a chance. On the contrary, if the judge is loyal to the government or politicians, or if they fear a disciplinary proceeding, my client's fate in this particular trial might be actually sealed. So this is my private perspective on our challenges and our troubles, our problems right now that we are facing regarding the so-called reform of judiciary in Poland. But these issues are not the only ones that lawyers in Poland have to face right now. The ongoing fight over the Supreme Court that we witness right now has entered a new stage, and the body which calls itself the National Council of Judiciary is in the process of electing new judges to the Supreme Court for the vacancies that are opened up by forced and, in my opinion, also unconstitutional retirement of judges, and by establishing the new disciplinary chamber. So the requirements to apply for the job are almost non-existing. Like, every attorney who practices for at least 10 years is welcomed to compete in this procedure for the vacancy in the Supreme Court, a procedure which is non-transparent and in fact actually secret. So the bar in Poland consists of more than 20,000 attorneys which are licensed to practice law in our country. As a professional, mandatory self-government, we are a pluralistic institution, pluralistic association. So I have to say that there is a variety of opinions on the appointment of Supreme Court judges in this procedure in our community, and unfortunately about 30 attorneys decided to apply in this doubtful procedure. And that met with an immediate response from the bar official bodies. Polish Bar Council, during a special assembly, passed two important resolutions regarding the election of judges of the Supreme Court. So in the first one, the Polish Bar Council states that, let me cite, the legal grounds and methods of election of judges breach the Constitution and European Union laws. And the Council also called for, in this resolution, it called for the President of Poland to refrain from appointing the candidates presented to him by the so-called National Council of the Judiciary to the positions of the Supreme Court judges. In the second resolution, the Polish Bar Council, in my opinion, recalls to the ethics of our profession. And it states that the participation of attorneys in the procedure contradicts with the principle that the bar should be guided by. The Council disapproves of such a conduct and considers it as a legitimization of activities directed against the judiciary which are contrary with the Constitution. However, I have to underline that according to many, for example, our own Warsaw Bar Disciplinary Fiscal, there is no reason to start any disciplinary proceedings against those candidates. And many attorneys do not consider such a conduct as a serious disciplinary offense or even a disciplinary offense. However, I also have to say that there are attorneys who think otherwise, me included. On the other hand, there are a few cases of attorneys who took part in the procedure whilst in the office, in the official function in the Polish Bar Council or District Bar Council. If I may use examples. Attorney Sławomir Zdunek, who decided to apply for the position of Supreme Court judge, was removed from the office practically immediately of a head of inspection division by Warsaw Bar Council. Another two attorneys, Mr. Adam Radzik and Antoni Bojańczyk, were removed from their position in Palestra. This is Polish Bar official magazine, upon decision of the Presidium of the Polish Bar Council. All these examples show us that attorneys in Poland are actually still discussing if applying for the Supreme Court in this particular procedure should be considered as a disciplinary offense. But that said, the situation of attorneys in office is pretty clear, since the Polish Bar Council repeatedly and officially condemned participation of attorneys in this procedure. An attorney who decides to do so whilst in office should expect to be removed from it. Unfortunately, the resistance of lawyers, including most attorneys and judges, as well as massive protests, massive street protests, in which, in defense of judiciary and its institutions, in which many of attorneys, many of us took part regularly, they have not stopped the executive power from devastating judiciary in Poland and rule of law in Poland. However, we hope that the fight is not over yet, and some of us, as for example Ms. Grigorczyk-Abram, are prepared to take it to another level, that is European Court of Justice. Thank you very much.
Thank you very much for this presentation. I need to add one thing, because sometimes even in the Polish public discourse there is some hesitance concerning this. This situation of those three lawyers is not about depriving them of the possibility to perform the legal profession.
No. It's about
they are attorneys, and nobody questions this, but it is the decision to deprive them of the possibility to perform certain functions within the self-government.
Actually, all functions. As we can see, two of them were removed from the editor's board of the magazine, official magazine. So it really goes deep. These are not the attorneys who actually hold offices, like higher offices in our bodies. So I can probably expect that every, because this is not over, right? There will be another recruitment, I guess. So I guess it is safe for me to say that every attorney who is functional, who has a function, an official function in our bodies, like, for example, Polish Bar Council or Warsaw Bar Council or other councils, will be removed from the office. Thank you.
Thank you very much for this clarification. Ladies and gentlemen, we know that the situation of the Polish judiciary is subject of the attention of different international institutions. Poland is part of the, unfortunately, of the rule of law procedure by the European Union, and within this capacity, European Union is producing a number of reports and statements. There were numerous reports and statements by the Commissioner for Human Rights of the Council of Europe. Recently, UN Special Rapporteur on Judicial Independence, Diego Garcia Sayan, presented his report in the Human Rights Council in Geneva, and my deputy, Mrs. Machinska, was presenting the view of the Polish Ombudsman on this. But I would like to underline that this issue is also subject of extensive attention of the OSCE Office for the Democratic Institutions and Human Rights here in Warsaw, which prepared a number of opinions on different legislative drafts, but also recently is organizing the rule of law roundtable, which is devoted to make deep discussions on the current situation in Poland. So it is my honor to pass the floor now to Andrea Huber, who is affiliated with OSCE ODIHR. The floor is yours.
Thank you very much, Commissioner, and good evening, everybody. Thank you very much to the organizers for the initiative and for the invitation, and I will try to summarize ODIHR's legal opinions that were issued, as you said, last year, and also report a bit about these roundtables held in 2018. So last year, ODIHR issued 4 legal opinions on the 2017 draft laws on the Supreme Court and on the National Judicial Council in Poland. And let me just tell you what these legal opinions actually are. One way in which ODIHR fulfills its mandate in assisting its participating states to put in place the commitments that they have taken upon themselves in the form of OSCE commitments as well as other international human rights standards, is to review upon request draft laws or existing legislation and assess to which extent they are consistent with these OSCE commitments and international standards. I can only summarize because of the complexity, but one area of concerns was the increase of the influence of the executive over the judiciary. And there are various examples of provisions to this end, the President being able to appoint a disciplinary representative, the executive determining the rules of procedure of the Supreme Court, provisions relating to the retirement age of the Supreme Court judges, which were already mentioned, the prerogative of the Minister of Justice to dismiss and replace presidents and vice presidents of common courts, but also the appointment of the 15 judge members of the National Judicial Council by the same rather than by peers. And in brief, this means that the legislative and executive powers exercise a decisive influence over the process of selecting judges in Poland, and that was one overarching area of concern. Another one was related to the introduction of extraordinary complaints. Quite a unique instrument. If you look at international practice, that means that final court decisions can be reopened And that is, of course, a problem with regard to legal certainty and respect for the finality of judgments. But also, ODIHR, in its legal opinions, was concerned about the wide temporal scope of being able to open final judgments, dating back during the transitional period, even until 1997. But also the vagueness of the material scope was an issue in the initial drafts. The wording was, I quote, to ensure rule of law and social justice, unquote. This wording has now been slightly changed in amendments, but the problem remains that the term social justice is very vague and does not have any clear definition. In its legal opinions, ODIHR also commented on the lawmaking process itself, noting that when initiating such fundamental reforms of the judicial system, the judiciary and the civil society should be consulted and should play an active role in the process in the spirit of OSCE commitments. Overall, the opinions raised serious concerns with regard to the key democratic principles, in particular separation of powers and independence of the judiciary. And it concluded that the provisions reviewed are incompatible with international standards and OSCE commitments on the independence of the judiciary and that they should not be adopted. ODIHR recommended at the time that the draft on the National Council of the Judiciary should be reconsidered in its entirety and that the legal drafters should not pursue its adoption. But as we know and as we've just heard, the laws have been adopted despite these concerns and concerns expressed by many other regional and international bodies. While ODIHR has not been requested to review the amendments that were adopted in April, May, and July, of course, in light of our previous engagement with the legal opinions, we've tried to follow up. And as becomes clear from what we have also heard from the previous speakers, the changes that were enacted in April, May, and July do not rectify the concerns raised in reference to the OSCE commitments and international standards. And ODIHR in this regard is very much in sync with other regional and international organizations. You have mentioned the Special Rapporteur on the independence of judges and lawyers, but also the anti-corruption body of the Council of Europe, GRECO, for example, in June has issued a very interesting report. Despite some minor changes, I would say, to some of the amendments adopted last year, the problematic shift towards the executive and legislative branches persists. The Institute of Extraordinary Appeals, which are, as I mentioned, jeopardizing legal certainty, have also been maintained, even if the number of stakeholders that can initiate it has been reduced. The 15 judge members of the National Judicial Council have been replaced in spite of the strong recommendations of ODIHR and others not to do so in this way. And presidents and vice presidents of common courts have been replaced in considerable numbers by the Minister of Justice, to mention just a few of the main concerns that ODIHR had raised in its legal opinions. And evidently the retrospective lowering of the retirement age of Supreme Court judges, including the first president whose term is incorporated in the Constitution, has received the most attention recently, and this is for good reason, because it is inconsistent with the security of tenure. Let me also report very briefly on the roundtables. This was another initiative that ODIHR engaged in this year to follow up on its legal opinions. There were many new developments, very complex new amendments, and so in order to provide a platform for experts to be able to discuss these new developments, we organized overall 3, and this year 2, expert roundtables to facilitate this exchange of view on the impact of these new laws on the rule of law. The roundtables were attended by approximately 30 participants, and they represented members of judicial institutions and associations, the Ombudsperson's office, local think tanks and human rights organizations, academic institutions, and representatives of the diplomatic community in Warsaw. Representatives of the government were invited but could not make themselves available. We also invited representatives of international organizations to make sure that their expertise and recent assessments can be conveyed to the community here, and that included the president of the European Association of Judges, representatives of GRECO, of the Venice Commission, of the UN Office of the High Commissioner for Human Rights, and also the Consultative Council of European Judges. The discussions were held under Chatham House rules, but I can provide you with a brief summary of what the main common themes were that were raised by the participants in these roundtables. One was the cumulative effect of the various changes to the laws of the judiciary over the past years. And I think it's very important to remind ourselves of the very comprehensive nature of these changes, starting with the Constitutional Tribunal, also the Prosecutor's Office, National Council of the Judiciary, Supreme Court, and Common Courts. Secondly, the lack of functioning scrutiny to check on the compliance of ordinary laws with the Constitution by the Constitutional Tribunal were a recurring theme that were mentioned by the participants of our roundtables and were reiterated particularly by the Special Rapporteur. And thirdly, the legal uncertainty that was created by a very comprehensive overhaul of laws relating to the judiciary in a very short time, without adequate consultation, and these repeated consecutive amendments, changing the initial amendments that were adopted just a couple of months earlier. And in conclusion, one thing that also was raised repeatedly, which concerns ODIHR not just with regard to Poland, but overall, is that there seems to be very little awareness about the importance of the independence of the judiciary and also the rationale of it. And as one of our keynote speakers in the Tuesday Rule of Law session has very eloquently elaborated on, it's not to create a system of privileges for judges, but rather the independence is a key aspect of the separation of powers, so that judges can decide merely on the basis of law rather than having to have an eye on their progression in their career and whether they can continue to be judges. Thank you very much.
Thank you very much, and once again, thank you. I would like to pass thanks on your hands to the OSCE Audio for your involvement and for your, I would say, passion in dealing with those issues. I know how difficult it is taking into account number of legislative changes. You know, when we are talking about changes to the Supreme Court legislation, we are already after the 6th amendment. So these days, the one which is implemented is the 6th one, and I think even very dedicated lawyers in Poland do not have enough energy to keep this pace of legislative changes. Now I would like to ask Dr. Piotr Bogdanowicz to elaborate on the European Union law perspective, because when we listen to discussions, what is happening in Brussels or in Luxembourg or here in Poland, we hear about rule of law procedure, Article 7, we hear about preliminary references made by Polish courts, we hear about infringement action which might be probably started before the Court of Justice by the European Commission today. Another deadline for the Polish authorities have expired, as well as we have already judgment of the European of the Court of Justice of the European Union on the European arrest warrant case, the so-called Selmer case. I would like just to add that Dr. Bogdanowicz is not only scholar at the Faculty of Law and Administration of the Warsaw University, he's also a lawyer having the regular commercial practice, but I would say that he's a frequent commentator to Polish internet portals, NGOs, as well as media on the current situation. And I would like to underline this because if you look into I would say, the general group of European Union lawyers, there are not so many of them that are courageous enough to make proper professional commenting on those issues. So thank you very much for this, and if you could please share with us in a couple of minutes just, the update what is going on in the EU.
Thank you very much, Adam, and thank you for having me here. As you said, today the deadline for Polish government has expired in the infringement proceedings. We do not know what the reply is, but I can bet that the Polish government said that the European Commission should not have intervened in the Polish judiciary reform, since the European Commission has no competence to review judicial reforms in member states. We often hear it. We often hear that the organization of judiciary belongs to member states, so the European Commission, the European Union itself does not have a competence to review it. And to some extent, partially, this is true. This is true that the European Union, the European Commission has no competence to review the organization of judiciary in member states. But the story here is not about that. It's not about that let's assume the European Union, European Commission says that in each Polish court there should be one president of the court and 4 vice presidents. The European Union cannot say that. But the whole story is about the independence of judges, impartiality of judges. And there is absolutely no doubt that the European Union, that the European Commission has the competence to review whether judges of Polish courts, being European courts, are impartial. And this was confirmed by the Court of Justice in a well-known case called Portuguese Judges judgment in the end of February, in which the Court of Justice said that the Article 19 can be a legal basis for review of national law in light of EU law. So, once again, the European Union has the competence. So what next? In the case of Poland, we have now 2 infringement proceedings. One of them relates to the common courts law. As you know, Judge Frąckowiak has already said that more than 100 of presidents of common courts were dismissed this year. The problem is that this complaint that has already been brought to the Court of Justice does not refer to the dismissal of presidents or vice president of courts. It only relates to the lowering of retirement age. Why is that? In my opinion, when the European Commission was referring the case to the Court of Justice, it underestimated the situation in Poland. The complaint was brought after the Portuguese judge's case. So the European Commission couldn't be afraid that the case will be dismissed. It's another problem, in fact, that European Commission brings to the Court of Justice only those cases which it can win. It looks at statistics. That's the problem. That's not the role of the European Commission. And I will get back to this issue in a moment. And we have now the second infringement proceedings. The European Commission has already said that on Wednesday there will be a meeting, and I hope that on Wednesday the European Commission will say that it goes to the Court of Justice with the Supreme Court law. But I hope that the European Commission will do 2 more things. That it will not only bring the action to the Court of Justice, but that it will also refer with 2 applications. One for interim measures, and the second one for an accelerated procedure. How much accelerated procedure is important, Hungarian examples says to us. In 2012, the European Commission referred to the Court of Justice 2 cases. One of them with the application for accelerated procedure, and the second one without. The one with an accelerated procedure was held by the Court of Justice in 6 months. The second one in 2 years. In 2 years, we will not have impartial Supreme Court in Poland. I'm pretty sure about that. Some months ago, Professor Wojciech Sadurski wrote an article, How Democracy Dies in Poland. If the European Union, if the European Commission will not do something with the judicial reform in Poland, so-called reform, I'm pretty sure that Professor Wojciech Sadurski or myself will be forced to write an article how the European Union let democracy die in Poland. It's the role of, the responsibility of European institutions now to intervene in Poland. And Polish judges show how much they believe in the European Union. To my best knowledge, in September and in 14 days of, in August and in 14 days of September, so during these 45 days, Polish judges have referred 5 preliminary rulings, 5 preliminary questions to the Court of Justice. 3 of them were sent by the Supreme Court, 2 of them were sent by common courts. To my best knowledge, 4 of them have contained application for accelerated procedures. To my best knowledge, all of them cover all the elements of the so-called judicial reform in Poland. So they refer to the retirement of age, they refer to the appointment of the so-called National Council of Judiciary, and then appointment of judges by this council, and this relates to the disciplinary proceedings. These cases, and we have to say it, these cases will not be easy for the Court of Justice, or the case of retirement should be easy. This law is against of EU law. I have no doubts about that. But let's take the case of disciplinary proceedings. One of the courts asked the Court of Justice that it has a situation in which it has the case against the state treasury, and it looks like that this state treasury may lose the case, so it will be forced to pay some money to the plaintiff. And the judge asks if the judgment will be against the state treasury. Does it mean that one day after the judgment, the disciplinary proceedings will be commenced against me? And the problem with this is that I do believe that judges can be afraid of such commencement of disciplinary proceedings. Nonetheless, in 1990, the Court of Justice has issued a judgment in some Italian case, Falciola, in which it said that psychological reactions of judges may not be basis for the judgment of the Court of Justice. In other words, the Court of Justice said, I do not bother about psychological reactions of judges. The problem is that the case was held 28 years ago. The case was about some public procurement, which is personally very important thing for me, since I am a lawyer specializing in public procurement, but I cannot compare public procurement on one hand and impartiality of judges on the other. And now we have extraordinary situation. And the question is, how the Court of Justice will look at this extraordinary situation. As Adam said, one last thing. As Adam said, one of the most important case that was recently held by the Court of Justice was the Selmer case, the case concerning European arrest warrant. And that was some surprise that after the judgment was held, there was not so many comments about that case. The case was held and there is a silence about it. Why is that? Maybe because of the fact that it was a preliminary reference case, preliminary ruling case. So what the court said, that was just the interpretation of EU law. And when we look at this case, the Minister of Justice was able to say, I do agree with this interpretation, but it's not the case of Poland. It's just the interpretation of law, and of course we are in line with those things. And that is why the infringement proceedings against Poland now is so important, since those cases will not be about the interpretation of law. It will be about whether the Polish law is compliant with EU law or not. Thank you very much.
Thank you very much. I remember that 1 year ago, Dr. Bogdanowicz, together with Dr. Taborowski, organized a conference by University of Warsaw and Max Planck Institute, where the issue of the rule of law was discussed and basically future proceedings. I think that we didn't even expect at that time that the situation will be so dire in Poland. But I remember that one of the issues that were mentioned at this conference was that asking a preliminary reference will be may have consequence with starting disciplinary proceedings against judges. At that time we discussed this in the context that referring directly to the Constitution may pose an argument for starting disciplinary proceedings, but now we observe that really those judges that are making those preliminary references are subject of questioning by disciplinary inspectors, and they may face potentially disciplinary responsibility. And I don't have doubt that it is about creating so-called chilling effect over judges, that, you know, please be aware that in case you are making that kind of a reference, you may have some professional problems. Now I would like to turn to our last but not least speaker, Professor Mirosław Wyrzykowski, who is former Dean of the Law Faculty, former head of the Human Rights Chair at the Warsaw University, former judge of the Constitutional Court, and I would just use this notion that he's our constitutional lighthouse. Judge Wyrzykowski.
Good evening. Thank you very much for invitation. You got not colorful picture of the situation in Poland. It's rather dark, gray, black picture, and I thought that my task should be to present what is at stake now and to give basic frame and especially anchor for persistence and resistance of brave, courageous lawyers in Poland. And I would like to offer 10 commandments. If you are in the country of roots of Christianity, 10 commandments is probably a good way. And I will start with the statement, basic, maybe even banal, that independence of judiciary is a universal and absolute value. And if it is the case, and if we see in, for example, in the basic principles of independence of judiciary of the United States, that the independence of judiciary shall be guaranteed by the state. It means the state is responsible for universal and absolute value as it is. Then we have to ask, what is a minimum level of independence of judiciary in the country, in this or another country. And it is indeed, we may derive this level from the history of the state, from the constitutional culture, from the legal culture of the state, of the society, or of the group of the state organized in a not imaginary but real community based on common values. And these two communities is the Council of Europe and the European Union. And this minimum of content is unconditional. Even more, is not negotiable and cannot be relativized. Because this minimum of content of independence of judiciary is a fact of tragedy of victims of abuse of power in the history, and it is also drama of other actors, as there are judges and lawyers and attorneys, not only of them, but also the families, relatives, and all belongings to the core of professional activity of these professions. And if the state does not guarantee the independence of judiciary, it means, from our perspective, it is not a constitutional state. And what is the task of the state, and indeed what is the task of legislator and other constitutional authorities? It is the task to follow some directives which should be exercised by all public authorities. Means the Parliament mentioned National Council of Judiciary, public prosecutor, the government, the courts, administrative courts as well, not mentioned yet. And the directives are, firstly, that the Parliament's mandate concerns only the admissibility of extending and strengthening the independence of judiciary. As a counterbalance, legislator is bound by absolute and unconditional ban on weakening and or limiting the independence of judiciary. It is ban imposed on legislator. And this prohibition, this ban, is may be applied both for direct or indirect restriction of independence. It means for this such of legislation which is focused on decreasing of independence of judiciary, or it is seemingly, might be seemingly neutral, technical, but as it was stressed by Andrea, we have to see cumulative effect of regulation. Then we may see what is going on, what is a real picture, real intention, and real goal of this seemingly unimportant technical regulation of the Parliament. Next commandment is that any regulation that reduces or undermines the guarantees of independence of judiciary is a violation of the Constitution. And all perpetrators should be aware that they violate the Constitution. And if it is a violation of the Constitution, it means that we are facing constitutional tort. And what is important, I know that I transpassed my time, that maybe the three sentences at the end. Firstly, that if we do not have an effective control of constitutionality of legal system, we will jump immediately into the situation of the lack of independence of the judiciary. Secondly, that if some of us may recall famous book Morality of Law by Lon Fuller. And in this book we have a set of rules concerning indeed rule of law. One of them is independence of judiciary. But what Lon Fuller said was that if you obey all these rules, it is not a promise of happiness of the society or the state. It's just a chance to avoid catastrophe. And I have impression that catastrophe knocks on the Polish doors. But catastrophe never ever waits for an invitation and enter and does not wait for courteous opening of the door. And once again, last question. My generation, we have had a dream on Poland. And now what we are facing and experiencing is a nightmare, not a dream. And I use this opportunity, please let me do it, to express my deepest respect to all members of the panel. And I would like to ask you to transmit this respect to your colleagues, members of your organizations, for your courageous behavior in the last 30 months. But the harsh time is ahead of us. Thank you.
Ladies and gentlemen, it is very difficult to start another part of our session after such deep and moving speeches. But being the moderator, I would like to ask you to take the floor. If you have any statements, questions you would like to share with us, I do believe still have some time to do it, and I'm pretty certain that members of the panel are ready to answer or comment to your questions or queries. So, okay. Mrs. Grabowska, Helsinki Foundation for Human Rights.
Thank you. I would like to start with the fact, although the picture is really not very colorful, I think there are still a set of tools that are still available for lawyers to challenge the current situation. And when one of the tools was already mentioned by Professor Dr. Bogdanowicz, meaning Celner case, who's already passed, and now this is the Irish court who is going to decide this case, and still the game is ongoing. It hasn't been finished yet. I remember in June, just after the Tanchev opinion about the case, the European Commission mentioned something like European arrest warrant is not a tool to solve the rule of law problem in Poland. And I strongly disagree with that statement, because there is a set of tools available in the European Union which can be used actually to fight with undermining the independence of justice. And I wanted to ask the members of the panels, imagine you are Justice Donnelly and you are Irish court. What kind of questions would you ask the Polish court about the independence of justice? to win this case, because if you read the reasoning of this decisions made by Justice Donnelly, she really wants to say, I do not allow to transfer Mr. Zelmer to Poland. I really believe that she doesn't want to, but she needs a good tool. She needs to ask a good question to get the good answer. So how would you ask the court, actually, how would you ask, dear colleague, are you independent enough to rule the case? I would be really grateful for your ideas, and if there won't be much time for such ideas, I would like you to invite you for our site event on Monday, just to follow up this, yes, it's a product placement, for if you have time actually to consider this idea also on Monday. Thank you.
Thank you very much. So let's collect maybe, I hope that there are still, oh, please. If you could please introduce yourself.
Hello, my name is Rafał Schindlauer. I'm a legal advisor in the European Commission. I'm involved in the analytical works of in the Commission regarding the situation in Poland already from November 2015, so from the very beginning of the whole dispute with Polish authorities on the rule of law. And I would like just to share with you my comment that we as a Commission and me personally, we fully agree with everything you said during this panel. The situation is really bad. It's even worse than we expected in our worst case scenarios that we drafted years and months ago, and every time the governing majority in Poland is crossing the red line that we think that will be never crossed. So we don't know really how the situation will evolve. We as a Commission, of course, we are guardian of the treaties, but also the guardians of the rule of law and the fundamental values which are established by the treaties. It's not only Article 2 of the Treaty of the European Union that contains all these fundamental values, but the legal basis for our interventions regarding the rule of law situation and independence of the Polish judiciary is basically established by Article 19 of the Treaty of the European Union and Article 47 of the Charter of Fundamental Rights of the European Union. So it's not true we have no legal basis to be interested in the situation of the Polish judiciary. We explained our position in 4 rule of law recommendations that we addressed to Polish authorities. So it's clearly, these 4 documents, they clearly show all our arguments and concerns. The last recommendation was issued on the 20th of December 2017, and since then we have another problems emerged, so we have even more concerns. But the major problem we face as the European Commission is that the Article 7 of the Treaty of the European Union, that is the major tool to fight with this kind of problems, is constructed in this way that at certain level of this rule of law procedure we need unanimity in the European Council. And we know that at least one country, namely Hungary, will block this procedure. So we have no tools to really influence the situation in Poland in an effective way, because this the major tool we have in the treaty to deal with this kind of situation is basically blocked by another EU member state that is having the same problems with on the rule of law with the EU institutions. And you know that this week the European Parliament decided to launch the Article 7 procedure against Hungary. So we may expect that both Poland and Hungary will defend each other in a framework of this procedure. And what we can do is only to impose the political pressure on Poland, and this is happening. But as far as I can observe, but this is my private opinion, the Polish authorities are ready to pay this price, and they are not very much interested in the damages that this situation is causing for our position in the European Union. But this is not the official position of the European Commission, of course. And we are trying to attack certain infringements in a framework of infringement procedure. Probably there will be more cases when in this procedure that will be launched by the European Commission, but this depends on our assessment and of course on the decision of the Commission. So this is what we can do right now, because we would like to do more, but we are not, we have no tools to react more in the current situation. But this is not because we don't want, but simply we cannot do anything more than what we are doing right now.
Thank you very much. Thank you for this contribution. Mrs. Machińska, Deputy Commissioner for Human Rights.
Thank you so much. Thank you very much for your presentations, but I think that we are in the middle of very chaotic so-called reforms. Maybe one can say that not chaotic, very well planned. The only element quite surprising for the ruling party and for the politicians, it was preliminary ruling procedure. Well, and this preliminary ruling procedure creates some kind of surprise and, in consequence, disciplinary measures. We are talking today about the EU law, but we should think about, to put this issue in a broader context of the European law, and especially we should also deal with the European Convention on Human Rights. What is for me quite worrying element of the European Convention? Well, that many judges are not very eager to lodge a complaint because of Strasbourg, it's a complaint against Poland, maybe it's not this type of reasoning. But in fact, I think that we should encourage judges to use this instrument, because, I'm really very surprised that many judges, also judges of the Supreme Court, are not at this stage. Maybe later they need a deeper reflection. They are not very eager to go with the complaints to the European Court, and I think that it could be a very effective protection on a larger scale. And I think, I would like also to make reference to the recent quite interesting article written by Professor Lawson in the European Judicial Review about the European Convention in this context. That European Convention was designed at the beginning for the very peaceful time. And now this European Convention will be exposed to a very serious turbulences of the judiciary in many countries. But until now, this is still one of the instruments in the hands of individuals.
Thank you very much for this contribution and comment concerning especially the role of international courts. I know that it is Friday evening, and so I'm really very grateful to you that you are spending this Friday evening with us. So maybe we'll take one. Mrs. Milena Bogdanowicz.
This way, okay. And I'm just a common lawyer. I'm not a member of any institution. I'm just a legal advisor who's trying to do her job properly in those hard times. And I just wanted to add one short, I promise, comment on the chilling effect that I noticed, because I also take part, and it's my honor to take part in those lectures in the association of Professor Hoda to teach kids about the Constitution, and I also try to support Wolny Sąd and other NGOs in this hard fight we have. And I also have many discussions with my friends who are legal advisors or advocates about the situations and what they do to support and to fight against what's happening. And I really noticed that it has changed, because at the beginning of this so-called reform, we did more. I mean, we published open letters, and such letters were also published by head of some chain law firms, and we did it, and it was great. We had this feeling that we are together and we consolidate, and we have this one voice against what's happening. But now it has changed, and I have this impression that it's not only because we don't see the point because reforms moved. I know that we actually are a little bit afraid because there are so many gossips that there is the list of lawyers and firms that are not afraid to comment on the situations, that are not afraid to sign open letters. And so many of us, especially lawyers who work in M&As or who represent public companies, they're just afraid, and they do not do more because they're afraid to be on this list. And if your name is put on the list, then you just don't get any work from public companies. And that's what Ms. Barabash said. I think that's what's happening with our minds. They just got us. We actually try to auto-censor ourselves because we try to predict what governments wants us to do. And I'm really afraid that I hope that we won't lack this courage, but seeing what's happening in my colleagues' minds, I'm really not optimistic about the situation. Thank you.
Okay, thank you very much for this statement. Okay, I think we don't have any more questions. I have two, so I will add two short questions to the panel, and it is up to the members of the panel to choose, which questions or which comment out of those that were asked you are going to answer. So one issue we didn't mention, in fact, during the panel is one of the major arguments which is behind the judicial reform, that it is about finishing with the Third Republic of Poland, and it is about getting rid of some post-communist elements, people from the judiciary. So my question is, what would be your response to this? And the second question is, I remember Zbigniew Janas, who is one of the dissidents from the Communist Times, made a statement that all of this is maybe about creating so-called technological chain, that there are a number of changes in the legislation, in the way how the state operates, that there is a technological chain which is used in order to restrict rights and freedoms. So my question is whether do we have already technological chain in Poland? So I leave your comments and questions and my comments to the panel, and basically it is up to the members of the panel to choose which one you are going to answer, but please try to keep limits of time because we are already after the time limit. Okay, so maybe we will start in the same sequence as we started.
Yes, very shortly about this question. that should Judge Donnelly ask? I would say, of course, in more formal way, whether this judge, a Polish judge who would deal with the case, can enjoy freedom in dealing, in adjudicating, or will he or she will be the subject of interest of the Minister of Justice? And I can tell you now the answer, but yeah, that very shortly. And another thing I can declare here, but I will not hesitate to file the motion against Poland to Strasbourg, but we all are very realistic, and we know how long these procedures are, and we know the cases of judges who sued Poland in 2007. Because I don't know if some of you know that President of Poland, Lech Kaczyński, didn't appoint some judges who came through whole the procedure and through also have good opinions from the Judicial Council, and these judges decided to go to Strasbourg, but finally when the government changed and president changed, they became the judges of the higher court, and it took, I don't know if there is any, I think there is a case still pending in Strasbourg, but so yeah, so we are aware of how long it takes in Strasbourg. So that's for me.
Okay, thank you very much. So maybe Mrs. Gregorczyk-Abel now.
I want to refer to the words that Ms. Milena Bogdanowicz said. I want to be a little bit more optimistic. I do agree that this is a very difficult time for lawyers, and all of them just have to pass this huge ethical tests, and not every of them are passing this test as positively. Definitely not. But I am also facing disciplinary proceedings because of that I dare to comment Parliament reactions and President reactions to the preliminary rulings asked in August, and I was aware of that, and I am actually aware of that this is not the last proceeding, and I'm really I really know that it's just the beginning. But as Justice Defense Committee, and Draginia probably will agree with me, we do observe lawyers that they keep asking us whether they can help with us, they offer legal assistance, they want to be very active, and absolutely every week I meet a lawyer that actually offers us his or her legal support. So I really hope and I really believe that we are not broken yet, and that's not the end, it's just the beginning.
Thank you very much. Now Mrs. Barabasz.
Well, addressing to what Ms. Bogdanowicz said, I think the difference is that at the beginning we were facing something that we thought gonna, go away soon. It was kind of a blitzkrieg. And now we are actually in the middle of a 3-year war, and it takes time and it takes energy. And as Professor Wyrzykowski said, the dark times are coming, the winter is coming actually, so we have to prepare and brace ourselves. And it takes a lot of courage, and I can imagine courage and energy to prepare yourself for such a war, considering what is going on now and what I'm sorry, I can't remember your name, but the representative of the Commission, European Commission said. The thing is that we weren't expecting that the government is going to cross the red line again and again, and we're still every time something happened, something bad happened, and they did it, we thought that this is the bottom of the bottoms, right? Nothing more can happen. And then another thing happened, like for example, the prosecutor is having trouble for teaching kids Constitution. This is absurd, right? So moving to another question about what Judge Donnelly could have asked, could ask the judge in Poland who will probably give information to her. I think that the only thing that the judge in Poland has to do is actually keep track on what the government doing right now when it comes to the disciplinary proceedings against the judges, because we know that we have 3 already, and the reasons for the disciplinary proceedings is really, as I said, absurd. So I would stick to the facts, and I will give only the basic information about against whom the disciplinary proceeding is being actually held and what is concerning. And I think that the judge, that Judge Donnelly will perfectly, she will basically know what's going on in a spur of a second. That's it? That's it. Okay. Thank you.
Okay, thank you. Andrea, would you like?
Yes, since our participants have the right to legal certainty of when they can go home, I will try to be very brief and just add one more thing which relates to the various other international organizations that have started to issue statements on Poland. So we've mentioned ODIHR, we've also heard about the various EU tools, but let me just mention a few others, and this is, I find, quite unprecedented in Europe, that so many institutions see the need to issue reports on a state of the European Union. So we have the UN Special Rapporteur on Independence of Judges of Lawyers, the Group of States Against Corruption, the European Association of Judges, the Consultative Council of the European Judges, the Association of European Administrative Judges, and the European Network of Councils for the Judiciary, and I've not mentioned all of them, I've just mentioned a selection of them. So I think this should really remind us that a lot is at stake and it's really serious.
Thank you very much for this, and I think that we missed to mention that we are waiting for the decision of the European Network of the Council of Judiciaries, where the Polish Council of Judiciary will be still a member. So it seems to me that next week this decision is going to be...
Sunday.
17th.
Yes.
Okay. Okay. Mr. Bogdanowicz?
Adam, not to keep you sad that no one replies to your question, I will try to answer what would I response to our government or Law and Justice Party talking about getting rid of communism. I will give just one example. I think that examples are very important when we are talking to, let's say, ordinary people. So the so-called reform says that, in principle, judges who are over 65 should be rid from the position. One of the judge that was appointed by the Law and Justice to the Constitutional Tribunal has already been over 65. The second one was nearly 65, so that was no problem at the time to appoint such a judge to the Constitutional Tribunal, and of course there is a problem if a given judge in the Supreme Court is over 65. I think that's a good image. Yep, thank you.
Thank you very much. And Professor Wyrzykowski.
Firstly, the question of Justice Donnelly. Could you imagine now that you will receive the questions from Ireland whether in this particular case, because it is what was said in Luxembourg, in this particular case, independence of judiciary is at the level of acceptance. if we are facing now disciplinary procedure against those judges which asked the questions, I can imagine that in the case of giving answer on the question, it's out of question that disciplinary procedure will be started against these judges. So I think that I hope that Justice Donnelly is aware of what is going on in Poland, and then she will decide what will be. Second, and two sentences, two questions. Third Republic means it is Poland, started in 1989, and Third Republic is a notion in the Constitution of 1997. And we have the same Constitution as it was adopted 21 years ago. But we have totally different constitutional regime in Poland now. So it is already done. We are rid of the concept of the Constitution in the field of separation of power, independence of the judiciary, parliamentarism, and so on and so on. It is my answer. And technological chain, back to the cumulative effect of the normative regulation. Yes, we have. And if it is chain, you need grease for smooth working of the chain. And what will be the grease? It will be fate of the Polish lawyers. Thank you.
Thank you very much. Ladies and gentlemen, the time has come to finish our panel, so thank you very much for your participation. I would like to thank our panelists for making their contributions and sharing with us not only their knowledge about what is happening in Poland, but also their sense of courage when it comes to challenges they are facing on a daily basis, and we are all facing on a daily basis. So let me, with maybe, like, there is this German tradition of making like this, so let me thank to everybody like with this, okay? With like the German style, okay? It seems to me. I learned it in Germany at least. So, and I would like to thank those who contributed to creating this panel. So first of all, I would like to thank representatives of OSCE, Katarzyna Garabchadze and Marcin Walecki, so leaders of the OSCE here in Warsaw, as well as OSCE officers and employees who are helping us in making this panel. And I would like also to thank people from the Office of the Polish Commissioner for Human Rights, Mrs. Machińska and Mr. Wróblewski, for this material contribution to the, for this intellectual contribution to the creation of this panel, and for the organization, to Joanna Rudnicka, to Miłosz Popławski, and to Mr. Mateusz Laskowski, and especially to Mrs. Anna Grzelak for making it happen. Thank you very much for this, and I would like to wish you a nice evening and nice weekend, and I hope that some of us at least will meet at the Rule of Law panel organized by the Helsinki Foundation on Monday. Thank you very much. Thank you.